So the Child Status Protection Act is a law that was passed to help families who had children who ended up sort of aging out of the process because of the long delays at USCIS. So what the government said was any time that the petition is pending with USCIS, the child's age is frozen as of the day the petition was filed with the government. Because previously, the age was not frozen, and a lot of children, as soon as they turned 21, lost eligibility. So this allows for the freezing of a child's age as soon as a 526 petition is filed with the government. Now, under CESPA, the requirement is that once a visa becomes available, you take the child's age at that time, you subtract it from the entire time your 526 petition was pending, and that's the child's CESPA age. And if that age is under the age of 21, they're eligible for the green card. Sounds really complicated, but the reason I mention it is because a lot of times if you start Googling CESPA, they do have this formula up. But essentially, you can consider your child's age frozen when you file the 526 petition, as long as there's no backlog. Then the requirement is that you then have to seek to acquire, meaning filing a 485, paying a DS-260 fee, filing a DS-260 application, filing an 824 application within 1 year of this becoming available, meaning that the 526 petition is approved or the visa is available. So when you are filing a 485 concurrently, and then there's a subsequent retrogression, the good news is that you already have done the sought to acquire requirement. And the as we've noted in the PowerPoint, there's no official guidance on this, but we've done this in other categories. So the I-140 petition that employers file for their employees have a similar mechanism for CESPA. And in those cases, the CESPA age has been frozen, and that does, filing the concurrent application does fulfill the seek to acquire requirements. So based on that, and if we were to extract what they're doing for the I-140 and apply it for the 526 petition, the children should continue to remain protected for CESPA benefits by filing a concurrent green card application. So for clients who have children who are 18 to 21, it's important that they file as quickly as possible because you do want to get them filed and protected before they turn 21. I have had some clients, and the reason at the outset I mentioned that there was a big boom in EB-5 in about 2015, and part of that was because there was expected to be a backlog for Chinese nationals in that category, and they very quickly tried to file before their children turned 21, and they were worried that that there was going to be a backlog in that category. So I expect something similar where more and more people are going to want to apply for this. And now that the RIA, the law that was passed in 2022, allows for concurrent filing of a green card application, there's now added protection for CESPA applicants. And I think it's going to be really helpful for those clients who have children who are 18 to 21.